Welcome. How to prevent your driver's license from being suspended, a guide for New York. When you're on child support and you cannot pay your child support, or you fall back what is called arrears, then the normal procedure is they're going to suspend your license. This is a guide for New York. I am not giving legal advice. I repeat, I am not giving legal advice. This is a guide for New York, and I'll explain later. We produce a video called Candace Owens is Dead Wrong. This is not a shot of Candace Owens. She is a wonderful person. However, she is dead wrong about child support. Preview that video. Let's start off with Missouri. St. Louis, Missouri, Wesley Bill was the Attorney General, and he said, I will not suspend driver's license while you're on child support. And it was a mandate. He had a couple of mandates, and he did that in 2019. Let's look at New Jersey. On March 2019, New Jersey will not suspend your driver's license. And the Attorney General, in this letter, Attorney General says, we write to apprise the court of the state through its agencies will cease the practice of the automatic suspension of the driver's license. So March 2019, New Jersey can no longer suspend your driver's license. The reason that no suspension of the driver's license is as a result of a lawsuit. Yes, as a result of a lawsuit. You can sue the agency for child support. And we have a video here, and we discuss other videos about how to file a lawsuit, and one in child support. We have a video called You Cannot Suspend the Driver's License in New Jersey. You can preview that video. Also, we have another video called You Can Sue the Agency for reporting on your credit report. You can sue the agency for reporting on your credit report, child support on your credit report. Preview that video as well. Now that New Jersey will not suspend your driver's license, so New York was very aware of what New Jersey is going to do. So they developed what is called restricted driver's license. And here it is, Department of Motor Vehicle. It's called restricted driver's license, which means you can pay, as a result of child support, you can pay about $75. I think it's now, it's up to $85, and you can still get your driver's license. However, there are restrictions. I don't know what the restrictions are, but the thing is, you can drive, but it's restricted. So if you're behind on child support and you have arrears, you're going to be restricted driver's license. However, you can pay $75, and you can do what's called a suspended license. Now, Article 1 versus Article 3. I am not giving you legal advice, okay? What we're doing is the procedures, because child support, the Department of Motor Vehicle hands off the child support, the suspension process, through a private organization. Okay, that's where the license suspension. So you have to file the procedures to get back your driver's license. And again, it's Article 1 versus Article 3. That is, it needs to be signed by a judge. The difference between Article 1 and Article 3 seems a little bit confusing. And again, we are not attorneys, so we don't know, which is which. However, there's an old saying, which is called the maxim of law. It says, ignorance of the law excuses not, and number two, ignorance of the law excuses no one. You deem to know the law, and that is, the case law is State versus Miller, June 19th, 2007. So you deem to know the law, whether you're an attorney, a judge, or just a layman, okay? You need to know the law. Hello, my name is Chris, and in this session, we'll review the procedures, not a legal advice, procedures for getting your license back if it's suspended in New York as a result of child support. Now, if you have comments or concerns, please feel free to reach us at chrish@289.protonmail.com. We do extensive research of how to get your license back. So we're asking for a gift of $25 or any amount, or Cash App for $5. We do extensive research and we bring that to you for free. Donate to our research and also subscribe to our channel so that we can bring you information on child support. You can also reach us on our podcast, which is Child Support Made Simple. You can listen to us on Apple and Spotify. Let's start off at the procedural process. In order to restrict your license, or as what I'm saying is, need to get your license back. So let's start off with the Administrative Procedure Act. You'll have a formal request from the DMV as well as the courts in order to initiate the Procedures Act.
Each state is required to establish its own administrative complaint procedure. This procedure must be defined by the state and designed to provide individuals with the opportunity to request an administrative review. This allows for appropriate actions to be taken if there is evidence of an error or if an action should have been taken but was not. This procedure is applicable not only to residents within the state, but also to individuals from other states who may be affected. This requirement ensures that there is a structured process in place for addressing potential errors and omissions in administrative actions. It provides a means for individuals to have their cases reviewed and rectified if necessary, thereby upholding the principles of fairness and accountability in administrative processes. The relevant case law that underscores this requirement is Bostick v. Department of Revenue, which highlights the importance of having such administrative complaint procedures in place to ensure justice and proper administrative conduct.
In addition, you need to know and understand jurisdiction. Jurisdiction is the cornerstone of our judicial process. Without it, they cannot adjudicate a case. So you need to understand jurisdiction. You need to study it. Also, you need to understand the 5 Supreme Court cases that you should already know. If you don't know it, please preview our video, the 5 Supreme Court cases that you should already know in order to understand how the DMV process works. Make no mistake, or you're confused about the process, but suspending your driver's license on all 50 states is illegal and unlawful. It violates the 14th Amendment. That is, once you have your driver's license in your possession, they cannot take it unless you're involved in an accident or you're a DUI. But you earn your license so you can have it. And the case law is Snediak versus Family Financing and Goldberg versus Kelly.
The 14th Amendment. No state shall make or enforce any laws which shall abridge the privileges or immunities of citizens of the United States. No state shall deny to any person within its jurisdiction the equal protection of the laws.
Let's review the Child Support Enforcement Program. The Child Support Enforcement Program is to separate you from your money. 72% of child support comes through income withholding. So the first step is suspension of your driver's license. Next, your federal and state tax returns. They're going to confiscate that. 3, any lottery winnings or any sort of settlement. And 4, your passport. Those are the 4 phases of the child support enforcement. The next phase of the administrative process, you need to have access to the DOJ letter, which is the Department of Justice letter. However, the Department of Justice letter was rescinded. But good news, there's a new Department of Justice letter, April 2023. You can formally file it within your case. But here's the process. You have to follow the rules of evidence. So some of the folks says, well, you need to file the Department of Justice letter and you put a thumbprint and you do an affidavit. No, you need to follow the federal rules of process, which is the court can take judicial notice for adjudicated facts, as well as it's not subject to reasonable dispute. And it's Federal Rules of Evidence 201BD. Again, that's 201BD. You need to study that rule. Many of the states says we only listen to state rules. We ignore federal rules. Well, child support is a federal program. So you have to listen to the federal government. And the Supreme Court case law that says states must obey the Supreme Court and cannot refuse to just follow them. So whenever you're in session, always remember we are dealing with federal rules, not state rules, federal rules. Here's the thing. What's wrong with driving with a restricted license? At least I just get my privilege back, but, I don't want to, take on the DMV. So I often reminded myself that Thomas Jefferson and Ben Franklin that says, the power of the government can only be kept within its constituted bounds by the display of power in of itself and the sentiments of the people. That is, it says, if you give up the essential liberty on obtaining, temporary safety, then you don't deserve liberty or safety. In order to challenge the restricted license, it starts off with the clerk, and it's called Federal Rules of Civil Procedures 5D4. You start the process by initiating filings with the clerk, and the clerk cannot refuse your paperwork. It reads that the clerk must not refuse any paperwork solely because it does not meet the state standards. Remember, child support is federal rules. As long as you launch a challenge, then the court cannot accept. In other words, they must not accept your paperwork. Remember, your clerk is a civil servant. They don't work for the courts. They're civil service workers.
The right of access to the courts is basic to our system of government, and it is well established today that it is one of the fundamental rights protected by the Constitution. I have the right to access the court at any time. This means that legally, a document is considered filed at the moment it is delivered to the clerk, even if it hasn't been officially marked as filed yet. This principle ensures that my ability to engage with the judicial system is not hindered by administrative delays or technicalities. The right to access the courts is a cornerstone of our system of government. It is a fundamental right that is firmly established and protected by the Constitution. This right guarantees that I, along with every citizen, have the ability to seek justice, challenge injustices, and have my voice heard in a court of law. It underscores the importance of an open and accessible judicial system as a key component of a fair and democratic society. The case laws are Biffle versus Morton Rubber Industry and Rilland versus Shapiro.
28 U.S.C. 1654. All courts of United States or parties may plead or conduct their own cases personally or by counsel. Again, I'm not giving you legal advice. I mean, you can have a lawyer if you want to, but you can plead your case yourself to challenge the DMV process. By all the rules, you are permitted to conduct your own cases.
The law doesn't grant him the right to have a lawyer, and it doesn't make it right for the court to force one on him when he clearly doesn't want one. As someone who values personal choice and justice, I find it deeply troubling that the court would impose a lawyer on an accused individual against their will. This goes against the very principles of freedom and autonomy that our legal system is supposed to protect. The case law are State versus Penderville and Moore versus State of Michigan.
You may need to review the history of child support. It's on the channel, but preview this in case you need to use the case laws. So there you have it. To challenge the DMV, the procedural guides to challenge the restricted DMV process in New York. If you have any questions or comment, feel free to reach us at chrish@289.protonmail.com. We do extensive research, and as well as subscribe to our channel. Our videos are free, but we ask to give a $25 gift or Cash App. We will accept any amount.